The 1044 is brought to you by Chevron Delo 600 ADF Ultra Low Ash Diesel Engine Oil. It's time to kick some ash.
This week on the 1044, what does Texas's new tort reform law mean for the trucking industry?
Hey everybody, and welcome to the 1044, a weekly webisode from the editors here at CCJ. I'm Jason Cannon, and my co-host on the other side is Matt Cole. Nuclear verdicts have been a hot topic in trucking for years, and the final verdict on how to fix it's in, but it always seems to come down to tort reform. Lawmakers in Texas last month passed a bipartisan bill, which has been signed into law, that enacts at least some measure of tort reform to help protect motor carriers from outrageous lawsuits.
That's right, Jason. The Texas legislature last month passed HB 19, which requires a two-phase trial in civil cases resulting from an accident involving a commercial vehicle, and adds a layer of protection for fleets whose vehicle has been involved in a crash. I spoke with John Esparza, the president and CEO of the Texas Trucking Association, who explained how the bill came about and how it will impact post-crash litigation. But before we hear from John, I'd like to take a second and tell you about the sponsor of this video, Chevron Lubricants.
Protecting your diesel engine and its after-treatment system has traditionally been a double-edged sword. The same engine oil that is so essential to protecting your engine's internal parts is also responsible for 90% of the ash that is clogging up your DPF and upping your fuel and maintenance costs. Outdated industry thinking still sees a trade-off between engine and emission system protection, and Chevron was tired of it. So they spent a decade of R&D developing a no-compromise formulation. Chevron Lubricants developed a new ultra-low ash diesel engine oil that is specifically designed to combat DPF ash clogging. Delo 600 ADF with OmniMax technology cuts sulfate ash by a whopping 60%, which reduces the rate of DPF clogging and extends DPF service life by 2.5 times. And just think what you can do with all the MPGs you're going to add from cutting your number of regens. But Delo 600 ADF isn't just about after-treatment. It provides complete protection, extending drain intervals by preventing oil breakdown. Before you had to choose between protecting your engine or your after-treatment system, and now you don't. 600 ADF from Delo with OmniMax technology, it's time to kick some ash.
You know, the legislation came about 6 years ago. We began to have conversations with our members about some of the things that they were seeing out there. An increase in these lawsuits that were occurring, and the outcome of them, they were often getting sued. And as your audience will know, a truck driver does not have to be at fault, nor company, to have a civil suit brought against them. And the instances of those occurrences were compounding, and it became one of those items that we began to talk about. And as we brought defense attorneys into the conversation and started comparing notes as to what they're seeing in the courtroom, we began to notice there's a pattern in this uptick. And then, and especially in the last 2 years, it seems like you can look back and say, well, the rest is history. The whole country knows what's been happening. It's been terrible in Texas. There's some other states that have seen the abuse probably worse than other states, and that has everything to do with the protections in each individual state. Starting September 1, and the governor has already signed this HB 19. HB 19 is going to protect Texans who are truly injured, and I think that's the first component of this. If you get involved in an accident with a truck, this will protect you. This is not about adhering responsibility on what commercial vehicle accidents may require, what may occur there, but this is going to protect the rights of Texans who get involved in accidents with commercial vehicles, but at the same time reduce opportunities for some of these trial lawyers to manipulate evidence at trial, in which they've been seeking millions and millions of damages in they've been seeking millions and millions of damages in cases where the commercial vehicle owner was not at fault, and where the plaintiff in many cases was not even injured.
The first phase of a civil trial, as John explains, will be used to determine whether the truck driver or the trucking company had any liability in a crash, which will help determine compensatory damages. The second phase of the trial, if it gets to that, will be used to determine exemplary damages.
What you're basically seeing is an abuse of the current practice in Texas courtrooms. So now a defendant can request a two-part trial in any case involving a commercial vehicle. Two-part trials are already used today in both criminal and civil cases. In all commercial lawsuits, effectively the negligence of the driver, the negligence of the employer in maintaining the vehicle, and compensatory damage are determined in that first phase of the trial. So in some cases, the employer's negligent entrustment, if you will, of that vehicle to the driver is also determined in the first phase. Therein is where we've seen the abuse. So the liability for the amount of the exemplary damages for all causes of actions is determined in that second phase of the trial. I've learned a lot about the trial process when it comes to this, but that was one of the areas that we specifically worked at to try to counter what's been occurring in the courtroom and the abuse that we've seen there in the courtroom.
Another thing the new law does is allows photos and videos to be admitted into evidence, which wasn't always the case in Texas.
Our bill also codified the well-established law of negligence per se. It creates a presumption that photos and videos of vehicles included in the accident will be admitted into evidence. Believe it or not, that's been one of the bigger issues. We will have, as you know, trucks there are more and more cameras in vehicles these days, and yet we weren't able to use that, or was subject to being subject to the judge either allowing it or disallowing it. It didn't take away the discretion there of the judge. I think that's important because I think we took a lot of criticism for what we were trying to take away from the judge, but we were effectively saying, look, we get it. The judge should be able to look at photos and evidence and see that that those are terrible photos. We want to subject a jury to that, or the plaintiff to that, or the defendant to that. However, far too often that was what was abused. We would have evidence of an accident in which, many cases, and we used photos of this while we were working this legislation, where we show where an accident in which $1.5 million was being requested, and we'd show evidence of the truck via photo of the vehicle and the truck, and you see such minimal amount of damage, being able to put forth that, well, this was $1,400 worth of damage. How are they suing for $1.5 million? But those aren't allowed in court. So that was part of what the bill also did, is it addressed that issue.
While this law could have a huge impact on trucking companies operating in Texas in the courtroom, don't forget about how it could impact insurance rates, which we all know have been skyrocketing in recent years, thanks largely to these nuclear verdicts.
HB 19 will literally save small businesses that are operating commercial vehicles across the state. We've seen lots of bankruptcies and closures, increasing, skyrocketing insurance rates, and that was part of the conversation. There was a lot of concern that it wasn't going to address the insurance rates directly, but we weren't interested in putting a bill forward that would regulate insurance. That's an entirely different animal. We were wanting to go right to the cause, knowing that if we made some waves and did enough with the practice of the reptile theory that's applied against the trucking industry, that we could have an impact on those rates. It's not going to happen overnight. It probably won't happen within 6 months or a year, but over the course of a couple of years, and we've seen this in other industries, you will see rates respond positively in the manner in which they've been abused for so many years, and those rates were just skyrocketing. In the last piece of it that came in through the process of legislation, in which this wasn't in the bill when we first worked with the authors in putting this forward, but due to the process, it was an amendment that was added late. But it's a good amendment. It would require the Texas Department of Insurance to conduct a 6-year study on the effect of this bill to insurance rates. And availability of that report and its findings would be brought back to the legislature. So we have the ability to come back in sessions, future sessions to come, and look to see just how much success that we've seen here. But I'll tell you, Matt, we have already seen success in other industries in which they've come in and made changes and adjustments such as this, for reforms such as this, and it has had a positive impact on the insurers.
And as with just about any law passed these days, there's almost always criticism to go along with it, and Texas's HB 19 is no different. John said, however, that the motoring public in Texas is still protected and still has a right to win damages following a crash.
This protects the rights of all Texans, all Americans who are involved in accidents with commercial vehicles, first and foremost. It just separates that trial so that the juries aren't biased against what actually occurred. I had a member of this association, a former chairman, as a matter of fact, within the last 4 months now, spent over 8 hours of deposition over an accident that occurred, and not a single one of those questions were about the accident itself. It was all about the company. It was trying, and that was the tack. That therein, as you know, is the reptilian theory. We're going to try to expose the jury to all these abuses within the company, or pick through that company and try to find something that says, "Oh my gosh, your abuse. This is terrible. You shouldn't have hired that driver. You shouldn't have put that practice in place," etc. Before we ever get to who caused the wreck and what happened, what the event that occurred here. And then to take it the next factor, it has gotten so bad that there are relationships between these plaintiffs' attorneys and doctors that they're setting up practices that exclusively work on these accidents, in which now you can today go out and invest. You can buy shares into that company that's being established primarily over these accidents. So it is, it's a profit center. And unfortunately, one of the things that we were looking at as well is who stands to profit in these accidents. You think that it's doing the right thing is carrying insurance in the event that we have an accident, and ensuring that we're taking care of the victims or all those that are involved in the accident when that accident occurs. But when the abuse is blown out so bad, you're seeing an environment in which, what you saw happen in Louisiana with the abuse and stage accidents, that's happening in the state of Texas. There's investigations currently in East Texas and in the Houston area of the exact same thing going on. All these things are allowed to happen because of the environment that we're in, and the only way to really get at the issue is with what we've attempted to do this session. And fortunately, we've seen some success there, and we're probably going to continue to work toward different areas in which we can protect what's occurring in that courtroom and ensure that it is fair.
That's it for this week's 1044. You can read more on ccjdigital.com, and as always, you can find the 1044 each week on CCJ's YouTube channel. And if you've got questions, comments, criticisms, or feedback, please hit us up at 1044trucking@gmail.com or give us a call at 404-491-1380. And until next week, everybody stay safe.